Hello, everyone. This is Professor Souvik Roy from School of Law and Justice, Adamas University. And like I promised, we shall look into Module 4, the final part of it regarding reputation of an individual and how crimes and criminal conduct affects the reputation of an individual. Goes without saying that two major provisions of law in this regard on this aspect are one, defamation, right at the thick of things, and two, criminal insult. So, in the last video, we had spoken about assault, intimidation, force, criminal force, and in the same breath, I'd probably touch base with criminal insult first and then move to the defamation laws. Now, when you talk about intentional insult, it is envisaged under 504 of the code that was there. Whoever intentionally insults and thereby gives provocation to any person, intending and knowing. So we are taking that intention and knowledge throughout because that's part of our penal system. The very substantive penal law is premised and based upon the Benthamite ideals and spirit taken further by uh, Lord Thomas Babington Macaulay. You know, whoever intentionally insults or thereby gives provocation to any person, intending or knowing, it to be likely that such provocation will cause him to break the public peace or to commit any other offense shall be punished with an imprisonment for description term which makes it up to 2 years or with fine or both. So if you talk about criminal insult, clearly there is this element of one-to-one interaction, and it's followed by the fact that there can be a possible breach of public peace. Now, when you insult someone in a very colloquial term, we use the word insult in English language, and all of us do. Oh, that was very humiliating. This person insulted me like this person told me that, etc. So, I mean, one can say that, go get lost, and some can also say, go see the moon. But in effect, both means the same. It's just that the way putting it or delivering it, it becomes different. It's like asking someone, can you give me water, please? And telling the same person, hey, give me water. So basically, you're asking for water because you want to quench your thirst. You're thirsty. But the approach in one, can you give me water, please? And approach in the second proposition, hey, give me water. The two approaches, two languages, the tone, the tenor are different. One attracts insult, the second one, that is the latter one, and the other one, the first one, attracts more politeness, humility, and therefore it cannot be termed as insult. And it's not insulting on the face of it, prima facie. So, keeping that spirit of the code going, what becomes even more further vital and fundamental is the fact that mm, when it comes to insult, clearly one person is saying things in a way with the intention and knowledge that the other person, on being said that particular thing, a sentence, a word, or a construction, or a language, whatever it is, will feel so provoked that the person will breach public peace. So clearly, the person knows, the alleged perpetrator knows that he is about to say something which will affect the other individual on the receiving end of the spectrum, will be hearing it act in a particular way because that person will feel provoked and insulted. And that's why the provision here rightly placed as intentional insult. Interesting to know. Of course, it's punishable like the way it has been put forth. Now, I still remember there was this particular case wherein, you know, there was a land dispute in the rural part and the suburbs. So, in order to settle the dispute, the matter was taken up before the honorable court and in the city, and both the parties had come to settle the matter on the day of the hearing. So, while in the cafeteria, the two parties, that is, one individual representing one party and the three others from the other, there was a heated exchange of words and conversations and certain gestures made that was very provocative. And as you can understand, in a court area, cafeteria is a public place, and any disruption happens there, it will definitely lead to breach of public peace. All said and done, what happened was an explicit word an expletive was rather used by accused number one and accused number two, a certain slang denoting the illegality of birth with respect to parents of a child. Now, accused number three, what he did was he said that, what else this person can do. So he wanted to be a part of the crowd because they were in the same group, same unit, but at the same time, he did not say anything provocative per se. He just kind of went ahead with his other two peers, brothers. When the case went to the court and for hearing, accused number three was discharged because his words were not provocative by nature, his words were not insulting by nature. However, accused number one and two, they were caught napping. Because in a public place, you say something about someone's parents and the source of birth, of course, it can be provocative. So the court demarcated the group into two is to one and gave uh, punishment for intentional insult to one couple of the accused and let the other accused go free. Under the circumstances, the first part of reputation offenses relating to reputation is clear intentional insult. And here is a one to one combat and one to one insult that is taking place, breach of public peace, etc. However, when you look into the major uh, definition of how offense against reputation is envisaged under the code, it is clearly and obviously a very colloquially understood word, and it has a very strong legal meaning with a lot of legal implications given with it. Is the laws relating to defamation? Clearly. Now, when you talk about the laws relating to defamation, one has to understand defamation in perspective. Section 499, read with Section 500, talks about defamation. And it's very interesting the way the section has been put forth because there are a lot of explanations, there are a lot of illustrations under Section 499 and 500, and rightly so because that's the way one should get into the aspect of defamation. Now, before we get into the provision, excuse me, let us first understand that, what is defamation and how did defamation come into the picture and you understand. Now, defamation can be categorized into two parts. One is slander, the other is libel. Now, slander is one form of defamation, libel is the other form of defamation. But before going into slander and libel, as per English laws, what is even more important is for us to understand that when it comes to slander and libel, it is very fundamental for us to understand a couple of things. Couple of things, as in, what would ideally to a layman defamation mean? It means that defamation is something that denigrates, vilifies, lowers down another person's reputation in front of other people. I say that Mr. X is a bad human being. Now, when I say to that Mr. X, you are a bad human being one to one inside a room, that can at the most may lead to insult, but that is also difficult because there's breach of public peace is impossible within four walls of a room. However, for defamation to have a publication is very important. A third party is very important. It cannot be one to one and be defamatory. Yeah, of course, civil action, civil suits, and all of that, but still the basics of defamation remains the same. So, therefore, when it comes to one, uh, it's not defamatory enough. But however, when you say something bad about someone in front of few others, then it becomes defamatory because you have put the reputation of that individual down in the eyes of others. Now, what do you mean by that? Here you're talking about publication, you're talking about information percolation. Now, when I talk about slander, remember a few minutes back, slander is something that is more in spoken, verbal, transitory form. Libel or libel is something which is more in a permanent form. What defamation used to be at one point and what defamation is currently, there's a huge difference because of the advent of social media into the platform. Today, post on a LinkedIn or a Twitter or Instagram or a Facebook or a WhatsApp story or Snapchat, multiple viewers or on the web e-content, multiple viewers are able to assimilate, absorb, and be privy to that information at one given point of time, which will be termed as publication. Similarly, that is in written form, printed form, or newspapers, etc., which are already there. Similarly, if I'm in a public gathering and I say someone loudly and I'm aware, I have the intention and knowledge, again, going back to the two important terms. Mens rea guilty mind denoting intention and knowledge is awareness of consequence that, if I say this here in front of this many people, then the victim's reputation will be at stake and victim's reputation will definitely go down in front of others. Or I give a call to someone, say that, this particular person is like this, blah, blah. Then obviously it would ideally mean that, there is this element of defamation that is there because it has been published to some other person, my viewpoint. So, slander being the transitory form, libel being the more permanent form, is from the English source of defamation, and then coming back here in the Indian context now. Both the forms of defamation are prevalent and pretty much possible in India. However, can honest statements be called defamatory? Like, can I call a thief a thief? Excuse me. Can I call a liar a liar? Can I call a bad human being a bad human being? Can I call a kidnapper a kidnapper? Can I call a murderer a murderer and tell that he's a murderer? Will that be defamation? The whole point of exception to defamation is honesty, good faith. Good faith is in section 52 of the code. And that becomes extremely fundamental, that becomes extremely vital because good faith becomes a very core of the entire thing. It is well understood that bona fide correct statement made in good faith with due and proper research is not defamatory by nature. What is defamation is wrong statement. What is defamation is false statements. What is defamation is something done deliberately with that intention of knowledge that will make a false remark and put the other person's reputation or stake down. That is defamation. Defamation is not about calling a spade with all due fair conscience, good faith. No, it is not. And that is exactly the point wherein some cases can be handy. Now, we are pretty much aware of the hashtag Me Too movement that has been happening for the longest time ever since. We are pretty much aware of the media trials that take place. We are pretty much aware of the lawyer client relationship. Now, if, say, for instance, somebody, client, goes to the lawyer and says something, or the lawyer says to the client something, of course it is not defamation because it will come under the exception of privileged communication. I repeat, I reiterate, it will come under privileged communication. It will come under privileged communication because of the very simple reason that when it comes to defamation, uh, it is important that the client and the lawyer speak to each other in due and honest terms, and therefore it is guarded, it's well protected. Sovereign immunities, etc. They're all well protected. Some kind of uh, information sharing of the higher ministerial levels, well protected under the laws. Now, let me take you to a case called of Jawaharlal Darda versus Ganpat Rao Kapsikar. Now, what happened in this case was there was a newspaper, Daily Lokmat, and in that newspaper, what happened was uh, certain editorials were written about some kind of financial uh, incongruency and matters relating to a particular political party and political leader and how funds were misutilized or wrongly utilized and there was corruption. So the concerned victim filed a case against the newspaper editor, the chief editor, and everyone, stating that this was defamatory by nature, and because of that particular statement made in the newspaper, it has led to serious repercussions, and repercussions were so strong that it further led to disparagement or lowering of the integrity and honesty of the character of the politician. Now, automatically, the lawyer for the defense was trying to defend this case on behalf of the newspaper organization. Stated that, they had published a report from the proceedings of the meetings that took place after due research. It was not something that was concocted. It was not something that was put forth by a figment of imagination or just because somebody has given some information. No, it was in verbatim, just placed from the minutes of the meeting of the assembly. And therefore, the Honorable Court felt that, when a public money, which is to be used for public good, was not duly used, and such report was published in good faith, with full honesty, without any kind of ill motive, intention, or knowledge whatsoever, it is but obvious that it will be not a case of defamation because there was no guilty mind involved in it. It was not a false statement per se. It was well researched and it was done in good faith, publishing things in verbatim, fact to fact, without tampering with the language or the knowledge or the communication. And Honorable Court decided in favor of the defense. Now, this clearly shows that defamation law, being a very important law, and it not only caters to the people who are living but also the dead, people who are no longer there. But even for them, it means a lot because the heir of the people who are no more can get directly affected by it. Now, there was this another very interesting case of M.S. Ahuja versus Amy Chand. What is important are the facts of the case. So, there was this office. Now, in that office, what happened was there was, of course, a finance section, and then the section where the administration would work, the top bosses of the administration. So the fight or the duel of insult and defamation was between two individuals, one from the finance, the other one was a boss at a higher cadre uh, compared to the guy who was working in the finance. Now, what happened is there was some few pending payments that were pending. Payments that were pending. Now, those pending payments were such that you know uh, had to be cleared. Now, as it happens with finance people, they look into the nitty gritty of things, go deep, dig deep, and find out all the fallacies, the problems that are there, here and there, XYZ. And like it happens in any office, they maintain files. So those files are basically for a particular transaction. What has happened? All the notes are mentioned, the details analysis, along with the notes. So it came from the higher cadre, from the administration to the finance. No problem in that. That the payments need to be made and approve the payment. So the finance office wrote that this is not being paid. Uh, the contract has not been duly reciprocated, and therefore this should not be paid. So in that file there was noting done. Fair enough. Now from the finance it goes back to the higher cadre officer. The higher cadre officer became furious seeing that note from a junior guy from finance, that how can somebody write something like this, that uh, you this cannot be paid. So he got so furious, then he wrote a counter note on that file stating that who is this idiot who can write such a thing on the file. Then, who is this idiot? The word idiot was scored off, struck off. and replace the word idiot with immature person. Who is this immature person who can write such a thing on the file? Close the file, sent it back to the lower cadre uh, finance office fellow. Now, once it came to the finance guy, he opened the file and there were a few others who were sitting with him. And after opening the file, he just realized that, something like this has been written. Who is that idiot? No idiot struck off. Who is this immature person who can write such a thing on the file? Done. Now, automatically, he gets furious at that. How can someone write to me like this and that on an official file? Now, the question comes up whether this is a case of defamation or not. Now, there are multiple aspects to it. Not that I agree with the decision of the Honorable Court here. The decision was that, it is not a case of defamation. I'll give the reason why, which I didn't find sound or logical from the realms of law and otherwise also. So it was told that, how come someone write something like this on an official file? Now, the one part of the story is when the official files are being exchanged from one department to the other department, it is mentioned, so it is clearly from one person to another person, uh, administrative designations. Now, unluckily for the finance person, when he opened the file, people are around him and they managed to peep in. So it termed as published because other persons have seen, they're privy to what has been, written. On the other hand, the other part of the story is the administrative person did not know that people will be around him. It is not supposed to be read or opened in front of other people because they're confidential files. However, having said that, the counter argument to that will be that at the end of the day, it's an official file, it's a public document for heaven's sake. And when there will be internal audit or external audit, the finance audit that happens in any organization, and if people, external agencies would go through it, and then suddenly something like this can catch the eyes and it will become a public mistake. Definitely, struck out the word idiot and replaced with immature. But is immature a word that can be taken into consideration as not defamatory if, in an official parlance and not so personal parlance, a parents calling their daughter or son immature is one thing, but in official parlance, in an official notepad, in a file, a word like this can have a very insulting connotation to a person's reputation. So, keeping that into view, keeping that in consideration, however, the court decided otherwise and said that, he did not have, the senior person did not have any kind of false or a bad motive or a bad intention whatsoever. And it was just uh, a kind of a banter towards the junior, and it is not to be taken so seriously either, which is not a very logical decision I felt from the Honorable Court, but not that it matters. The decision has been pronounced long back and it remains as it is. But this is also a case where I felt this is strong case wherein defamation should have been strongly attracted. Maybe the quantum of punishment could have been delineated a little bit. Now, this is definitely not a privileged communication within the facial cadre. So when you look into section 499, let me tell you, it said that, whoever by words, either spoken or intended to be read, or by signs, or by visible representations, makes or publishes any imputation concerning any person impending harm and knowing or reason to believe, section 26 of the code, like I mentioned before, It will harm the reputation of the said person. Hereinafter, you defame that person. You vilify that person. You denigrate the status of the person. You denigrate, you bring down, lower the reputation in the eyes of other people, in the eyes of other human beings. So, this becomes a very important parameter. There are a few explanations to it. Explanation one talks about the deceased person. Explanation talks two talks about the company or the association. It talks about explanation three talks about this alternative forms of expression in the form of innuendo. I can say that, Mr. Ram is a very good man. And I can also say, oh, Mr. Ram, I know how good a man he is. He is a very good man. So, in effect, the language is communicating something, but however, in the latter case, the innuendo in the tone and tenor is communicating very opposite to which what was said in the former case. So, first one is a clear case of honest expression of someone's feelings or thoughts about someone else. But in the second one, it is definitely a clear case of gross defamation because you're trying to say something that you don't mean and you're expressing it in alternative form in the form of an innuendo. Taking it further, uh, if you look into section 499, it has got some important exceptions. Now, exception one being imputation of truth, public good, which requires to be published. We have discussed one case to that effect. Public conduct of public servant, again, the same Jawaharlal Darda case applies here in exception first and second. And the third exception is conduct of any person touching any public question. So again, what is meant for the public, if in all honesty and good faith things are put forth, it is not defamatory. That's the whole and soul of moral of the story. Then you got the fourth exception, which talks about court proceedings, as in the court the proceedings are. So if that's duly published, it's a true report. It is not something that is concocted. If it is not, then it's not defamatory. And last but not the least, merits of a case decided in a court conduct the witness and others concerned. So again, it's in furtherance or corollary to the previous exception pertaining to court cases. Then, once you move on, you'll find that there is the sixth exception. It talks about merits of public performance, and the seventh exception talks about censure passed in good faith, having lawful authority over the other. Now, this seven exception, of course, there are more. We'll come to that later. Now, merits of a public performance. So today, we all know that Sonu Nigam is a legendary singer. Now, Muhammad Rafi, Kishore Kumar, for that matter, Elton John, Celine Dion, Britney Spears, like you name like anyone. Now, just because, or for that matter, actors or sportsmen or athlete, just because I like someone, it's not necessary that the other person will have to like the other person as well. Some might feel Arijit Singh to be a better singer than Sonu Nigam, and some might feel otherwise, and some might feel that this song has not been sung well by Mr. X. Maybe Mr. Y would have been better. He sounded like this, blah blah. Now, when it's a public performance, it is always up for public scrutiny. So, a value judgment on a performance cannot be defamatory. But if a judgment goes personal with respect to that person, then it can be defamatory, provided you do not know and there is no honesty or truth to it. Then, if you look into the seventh, or you discuss eighth is accusation preferred in good faith to authorized person. Ninth is imputation made in good faith by a person for protection of his and others' interest. So any imputation made in good faith protect his own interest or others who are related. Then, 10th exception, caution intended for a good person to whom conveyed for public good, very fundamental. And of course, punishment, 2 years, etc. Now, therefore, it is clear by now that this entire aspect of defamation is covered within the ambit of lack of truth, is covered by the ambit of dishonesty, covered by the ambit of wrong falsified statements. I touch base here with the hashtag MeToo movement. There are multiple uh, shout outs and call out of individuals who happen to be sexual predators and at a fiduciarily at a higher strata who misused and abused the form of their power in order to extract sexual favors in lieu of giving better offers to individuals, to women, men alike. Now, letter Fee Ford is again one of the classic case of defamation law wherein versus Revlon INC. Um, a woman was the lady here in this case, the victim was harassed and molested, and subsequently, when she wanted to take it ahead, uh, she was threatened and aspersions on her character was put forth. So, having said that, it is important uh, to understand that aspersions on character being put forth without a legitimate, verified understanding is wrong because it is not made in good faith, because it is made in bad faith. There is no truth to it. As long as you substantiate your points, your statements, your remarks about another person with due honesty, it is not defamatory. It is not defamatory. And that is the whole crux and whole and soul of the law pertaining to defamation in India in code. I hope this has been an engaging session for you people. With this, we end module 4. And as we come to a culmination, brief wrap up of what we did across the multiple videos. We touch base with assault, criminal force, criminal intimidation, wrongful restraint, wrongful confinement, intentional insult, and defamation, amidst other things, with the aid of case laws, illustrations, and last but no the least, uh, definitely a lot of discussions. Hope this was helpful. And on that note, we'll sign off as we complete and end module 4. Thank you for your patient hearing. Signing off. Thanks.